Picture this. You're settling into your favorite chair, earbuds in, ready for a story that threads courthouse filings, political intrigue, and unanswered questions into a single, unblinking narrative. Before we dive in, imagine stepping through a doorway where every fact is explored, every document is opened, and no shadow is left unsearched. Then ask yourself, why would I ever want to miss an update like this? If that thought makes you nod even a little, tap subscribe, nudge the like button, and let your own comment join the conversation. That instant participation fuels News Decoded, the place where we never skim the surface. We drill until sparks fly. The United States Department of Justice has just filed a 40-page answer with the Supreme Court, and that answer targets one overriding request: Ghislaine Maxwell's petition to throw out the sex trafficking convictions she picked up in New York federal court back in 2021. Her lawyers insist that a non-prosecution agreement Jeffrey Epstein negotiated with federal prosecutors in South Florida nearly 2 decades earlier should have protected her as an unnamed co-conspirator. The Justice Department now says absolutely not. It is asking the justices to deny what lawyers call certiorari, essentially to refuse to hear the case at all. Maxwell's argument takes us to 2007 and 2008, when Epstein was under investigation by the U.S. Attorney's Office in Miami. Alexander Acosta, yes, the same man who became Secretary of Labor during Donald Trump's first term, oversaw that office. Prosecutors there, in a deal hammered out largely behind closed doors, agreed they would not pursue federal charges if Epstein pleaded guilty in state court to soliciting a minor. It was a startling arrangement. A billionaire walked away with a remarkably light sentence, and the agreement reportedly contained a clause shielding unnamed co-conspirators from federal prosecution. Fast forward to 2025. Maxwell, now serving 20 years at a federal facility, insists that clause protects her. The Justice Department's new brief calls the clause highly unusual, argues it carries no weight outside Southern Florida, and maintains it never bound the wider DOJ or the Southern District of New York, where Maxwell was tried. Put bluntly, the brief treats the clause as a local contract that never restricted prosecutors in other districts or the public interest in pursuing traffickers of children. Those are the dry legal bones, but they animate a far more tangled body of facts. From 1994 to 2004, the DOJ brief states, Maxwell coordinated, facilitated, and contributed to Jeffrey Epstein's sexual abuse of numerous young women and underage girls. She and Epstein, the filing recounts, identified vulnerable teens, isolated them from friends or guardians, groomed them with gifts and promises, and finally exploited them at properties in Palm Beach, Manhattan, and elsewhere. In plain language, prosecutors are reminding the court that Maxwell's actions were deliberate, sustained, and predatory. The brief also stresses conviction counts: conspiracy to transport minors, transporting a minor, and sex trafficking, each under a different federal statute, each carrying its own steep sentence. Why does this matter beyond the courtroom? Because the players, dates, and documents create a map that intersects with modern American politics. Epstein's 2007 deal bore Acosta's signature. A decade later, Acosta was tapped by President Trump to run the Labor Department, the same executive branch agency that polices human trafficking through its wage and hour division. Critics asked then, and ask again now, how a man who approved a lenient arrangement for Epstein could ever supervise anti-trafficking enforcement. When Acosta faced reporters at the White House in 2019, standing inches from President Trump, he said many people once considered the deal appropriate. The president called him a tremendous talent and lamented his eventual resignation. In her petition, Maxwell leans on precisely that connection, claiming Acosta's deal should apply nationwide. The DOJ counters that such a reading would turn a single U.S. attorney's signature into a blank check for traffickers everywhere, a result Congress never intended. Part of the fascination stems from the flurry of deadline extensions that preceded this Supreme Court filing. The government twice asked for more time, the last extension letter landing on June 6, 2025. Within 24 hours of that date's passing, former President Trump posted online that the so-called Epstein list either doesn't exist or, if it does, is somehow a hoax devised by political rivals. Maxwell's supporters seized on that post, arguing it proved a governmental cover-up and bolstered her right to a new trial. They circulated assertions that one woman is serving 20 years for trafficking minors to no one, ignoring the mountain of testimony and documentary evidence that identified her as the linchpin in Epstein's operation. Among those supporters is an online influencer we'll call Jennifer. She was photographed earlier this year visiting the White House in a Free Ghislaine t-shirt. Jennifer now pledges to push for a retrial or a pardon. Meanwhile, a talk show host we'll call Mark, a one-time fixture on the same political conference circuit, proclaimed on air, "I'm done talking about Epstein, urging listeners to trust my friends in government." Skeptics ask whether such abrupt silence is strategic, a way to tamp down questions about who appeared in Epstein's private flight logs or socialized at his Palm Beach mansion. Inside Congress, Representative Mike Lawler, a Republican from New York, echoed that shrug, "If somebody did something, prosecute them. In the absence of evidence, what are we talking about?" Yet a leading fact-checking service noted that the FBI's deputy director reportedly stayed home one recent Friday, protesting how the Justice Department handled parts of the Epstein dossier. Shouting matches inside the West Wing, according to multiple outlets, suggest the matter is far from settled. Let's pause on the human dimension. Virginia Giuffre, homeless at 17, took a spa job at Mar-a-Lago, where she says Maxwell first approached her. In television interviews recorded before her civil settlement, Jeffrey described training that began immediately. Be subservient, stay silent, give Epstein what he wants. Many viewers first heard her story years after Epstein died. The DOJ brief underscores that for jurors, her voice, and the voices of other survivors, proved decisive. Turning back to the Supreme Court petition, it rests on 4 legal pillars. First, Maxwell claims the 2007 agreement created a non-prosecution promise that binds the entire federal government. Second, she argues prosecutors in New York violated that promise, so her indictment must fall. Third, she insists the indictment also flouted her constitutional right to due process. And fourth, she suggests the trial court erred by excluding evidence she says would have shown the non-prosecution deal shielded her. The Justice Department dismantles each pillar. The agreement named only Epstein. No statute grants one U.S. attorney power over all 93 others. Due process was fully honored, and the trial judge correctly ruled that nothing in the Florida deal barred the New York case. A critical sentence appears on page 18 of the government's brief. Even assuming arguendo that the non-prosecution agreement applied to co-conspirators, petitioner fails to establish that any such promise was breached in this district. In plain English, DOJ attorneys concede only for argument's sake that the clause might exist, then immediately note it never covered New York conduct and never removed Maxwell from the reach of Section 1591, the federal sex trafficking statute. Legal language can sound cold, so let's translate its consequence. If the Supreme Court declines review, Maxwell's conviction stands, unless she uncovers new evidence that satisfies the demanding standard for a federal habeas petition. Her 20-year sentence remains intact. She would be eligible for release in her mid-70s at the earliest. Behind the scenes, defense lawyers are likely scanning every public comment for material they might spin into newly discovered evidence, or an argument that public prejudice tainted the jury pool. That's where former President Trump's social media post becomes fodder. His claim of a hoax could be cited to argue government inconsistency or suppression of evidence. The DOJ brief anticipates such moves by detailing how thoroughly prosecutors disclosed records, how stringently trial judges screen jurors, and how carefully appellate courts already weighed her complaints. What about the broader effort to unseal the list? Laura Trump, interviewed recently by Mark, ventured that more transparency is coming, hinting at additional documents that could shed light on who flew where and when. If further names emerge, public pressure may mount for congressional hearings. Yet senior House Republicans reportedly argue behind closed doors that subpoenaing Maxwell would create a media circus while offering little legislative benefit. They prefer to let the courts speak first. Outside Washington, survivors' advocates stress a different reality. Victims wait years, even decades, for credible reckonings. They point to the way Maxwell's trial allowed women to testify under oath, confronted by cross-examination and judged by a jury. Those advocates argue that honoring such verdicts deters future traffickers more than any list ever could. Add one more layer, the question of powerful men in Epstein's circle. The DOJ brief references a pattern of control that spanned continents. Records show Epstein socialized with heads of state, billionaire financiers, academics, and royalty. Maxwell's supporters vigorously repeat that no male clients have been prosecuted on trafficking charges. Prosecutors counter that successful cases demand admissible evidence of specific acts, not suspicion born of proximity, all of which leaves the Supreme Court as gatekeeper. The court receives roughly 6,000 petitions each term and hears fewer than 2%. Maxwell's odds are long, especially because her claims involve no new constitutional question. Rather, they challenge how lower courts applied well-settled doctrine. Within months, sometimes weeks, the justices may issue a one-line order, certiorari denied. If that happens, the matter returns to the trial court for any remaining housekeeping, and Maxwell remains where she is. Still, the politics refuse to cool. Certain commentators cast the Justice Department's rigidity as evidence it fears what Maxwell might disclose if granted a new trial. Attorneys who negotiated the 2007 agreement argue that in their era, a state plea with jail time and restitution looked preferable to protracted litigation that might have yielded nothing. Critics counter that wealthy defendants routinely exploit delay, draining victims' resolve until prosecutors accept lesser pleas. Both narratives hold pieces of truth, neither tells the whole. Consider, too, the role of Florida's Attorney General at the time, Pam Bondi, now employed as special counsel in Washington. The DOJ brief notes that state prosecutors agreed to handle charges while federal prosecutors deferred. That coordination, routine in some contexts, became deeply controversial once Epstein's crimes fully surfaced. Today, legal scholars cite the episode as a case study in how fragmented jurisdiction can dilute accountability. The debate, then, isn't merely about one woman's sentence. It is about who commands public trust when crimes span state lines, social circles, and years of official inattention. It is about whether the law speaks equally to boardroom magnates and teenage runaways. It is about the credibility of institutions, courts, Congress, the media, when survivors recount exploitation and demand recognition. So where do we stand tonight? A fresh Supreme Court filing rejects Ghislaine Maxwell's plea. A former president's post muddies the rhetorical water even as prosecutors chart a path forward. Influencers and members of Congress split into camps of urgency and dismissal. Survivors watch, weighing whether justice is still moving or caught in political crossfire. And you, our community here, hold a vital role. The more you interrogate, share, and question, the harder it is for any story to vanish into sealed records. Your curiosity is a lever that pries documents open and keeps cameras rolling outside courthouses at dawn. Before we wrap, take a moment to picture a future broadcast where the smoke has cleared, unsealed files name names, and readers count on NewsDecoded to parse every page. If that sounds like a conversation you'd hate to overhear secondhand, make a small decision right now. Click subscribe, ring the notification bell, drop a comment that tells us which unanswered question keeps you up at night. Then share this update with one friend who still thinks the Epstein saga ended in 2019. Together, we'll follow the docket, the hearings, and the human stories until every last piece of the puzzle is set in place. This is News Decoded, where no file is too thick, no timeline too tangled, and no power too great for the truth.